Then we have another provision in the same section which talks about compensation for failure to discharge obligations arising under the quasi-contracts. We had seen in the earlier class that there are 5 different situations which are discussed in sections 68, 69, 70, 71 and 72 of the Contract Act, where actually there is no contract. Still, there are certain obligations which are cast by these sections on the person who is receiving some benefit. And they were all these 5 sections are based on the doctrine of unjust enrichment. And in all those cases, under all those sections, whoever receives certain benefit is supposed to fall under certain obligation and he is required to discharge that obligation. So if somebody who has been burdened with that obligation fails to do that, then he has to make compensation to the other party. And how is that to be done? The section says, when an obligation resembling those created by a contract has been incurred and has not been discharged, an obligation resembling that created by a contract. Which are those obligations? As I told you, obligations arising under section 68, 69, 70, 71 and 72. These obligations resemble a contract, and if these obligations are not discharged, then any person injured by the failure to discharge is entitled as a right to receive the same compensation from the party in default as if such person had contracted to discharge it and had broken his contract. So even though actually there was no contract between the parties, yet the same obligation will follow, and in case of breach, the same compensation will follow as if it were a contract.